What is the role of a director in a private corporation, small or medium-sized business enterprise? The role of a director in a small or medium enterprise is defined by the applicable business corporations legislation that incorporated and controls the private corporation. Unlike large public entities, where directors might be detached from daily operations, directors in small and medium enterprises often wear multiple hats, acting as both high-level strategists and occasional operational advisors. They are legally responsible for supervising the management of the business and affairs of the corporation to ensure its long-term viability. This oversight involves approving major corporate policies, authorizing the issuance of shares, and declaring dividends when appropriate. Ultimately, the director serves as the ultimate authority figure who steers the corporate ship through the complexities of the private corporate business sector. One of the most critical aspects of a director's role is the fulfillment of fiduciary duties, which require acting honestly and in good faith with a view to the best interests of the corporation. This duty is owed to the corporate entity itself rather than to specific shareholders, which can sometimes create delicate situations in family-owned or closely held small and medium business enterprises. Directors must avoid conflicts of interest and ensure that their personal gain never takes precedence over the company's financial or legal health. If a conflict does arise, they are mandated to disclose it immediately and recuse themselves from any related decision-making processes. Failure to uphold these duties can lead to personal liability, making it a cornerstone of their professional conduct. In addition to fiduciary duties, directors must exercise a specific duty of care, which demands the level of skill and diligence that a reasonably prudent person would exercise in comparable circumstances. In the context of a small or medium enterprise, this means staying informed about the company's financial status and the regulatory environment in which it operates. Directors cannot simply be silent partners or figureheads. They are expected to attend meetings, review financial statements, and ask probing questions of management. If a director is negligent in their oversight, they may be held personally responsible for corporate failures or losses. This ensures that the leadership remains engaged and accountable for the company's trajectory and daily integrity. Both Canadian federal and provincial law also imposes significant statutory liabilities on directors that go beyond general corporate governance. For instance, directors of private corporations can be held personally liable for up to 6 months of unpaid employee wages and any vacation pay owed to staff. They are also responsible for ensuring that the corporation remits source deductions, such as Canada Pension Plan contributions, employment insurance premiums, and goods and services tax. If the corporation becomes insolvent and these taxes remain unpaid, the Canada Revenue Agency can pursue the director's personal assets to satisfy the debt. This underscores the necessity for directors to maintain rigorous financial controls and regular audits of their remittance schedules. Strategically, the director of a small or medium enterprise is responsible for setting the company's mission and ensuring there are adequate resources to achieve it. This involves long-term planning, such as deciding whether to expand into new provinces, invest in significant capital assets, or seek external financing. In many small businesses, the director also plays a key role in succession planning, ensuring that the business can survive the departure of key founders or executives. They must balance the immediate needs for cash flow with the long-term goal of increasing the corporation's value for its stakeholders. By focusing on the big picture, directors help the SME navigate market volatility and competitive pressures. Risk management is another pillar of a director's responsibilities, particularly regarding environmental and safety regulations. In Canada, directors can face personal liability for environmental infractions committed by the corporation, such as spills or improper waste disposal, unless they can prove they exercised due diligence. They must ensure that the company has robust health and safety protocols in place to protect workers and comply with provincial labor laws. This involves involves implementing reporting systems that allow the board to identify potential hazards before they result in accidents or legal action. A proactive director mitigates risk by fostering a corporate culture that prioritizes compliance and ethical behavior at every level. The relationship between the director and the shareholders is a defining feature of private corporations, often governed by a unanimous shareholder agreement. In many Canadian small and medium enterprises, a unanimous shareholder agreement may actually strip directors of certain powers and grant them directly to the shareholders, which also shifts the associated liabilities. Directors must be intimately familiar with these governing documents to understand the exact scope of their authority and where their decision-making power ends. They act as a bridge, communicating the corporation's progress to shareholders through annual meetings and financial reports. Maintaining transparency in these communications is vital for maintaining trust and preventing costly shareholder disputes or oppression claims. Finally, directors are responsible for the legal maintenance of the corporation, ensuring it remains in good standing with government registries. This includes filing annual returns with the appropriate corporate registry to avoid the administrative dissolution of the entity. They must also ensure that the corporate minute book is kept up to date, documenting all resolutions, meeting minutes, and changes to the share register. While a corporate lawyer or secretary often handles the paperwork, the legal burden of ensuring these tasks are completed rests squarely on the directors. By maintaining these records, directors protect the corporation's separate legal personality, which is the very thing that provides limited liability protection to its owners. To learn more about our corporate law legal practice, we welcome you to visit our website and contact our law firm to schedule an initial consultation. Thank you.